Welcome to A Peaceful Path, special education legal advocacy for families with children that have special needs.
Hello and welcome to A Peaceful Path with Michelle Becker, the podcast that empowers parents of children with special needs to navigate the education system with confidence and clarity. Michelle is a special education attorney and passionate advocate for families across Los Angeles County. My name is Kevin Rosenquist, and today we're talking about something no parent wants to hear. No. Whether it's a denied IEP, rejected 504 plan, or a refusal to assess your child. When the school says no, you don't have to accept that as the final answer. Michelle, welcome back. It's great to see you.
Thank you. It's great to see you too. Thanks for having me back.
Yeah, I'm interested to talk about this. Let's start here. What are the most common types of denials that parents receive from schools when trying to get services for their child?
So there isn't necessarily one common type of denial. I think it's more process related denial. So for example, the first thing, maybe you have a parent who in kindergarten, or their kid is in kindergarten or first grade, and they're noticing, okay, so my kid isn't reading as well as the other kids, or they're not catching on as quickly as the other kids. The parent's first response is, will you assess my kid? And there's usually a wide-ranging variety of responses, like, oh, he's young, she's young, she'll catch up, I see that she's doing okay. And they usually direct that question right to the teacher. And in fact, there's an actual process by which you go through to not hear no, but hear, well, let's see what we could do. Mm-hmm. And so basically, if you, and I say this all the time to any potential client or to actually any person, if you think there's something wrong, mommies and daddies are right 99% of the time.
Yeah,
they may not know exactly what they're right about, but they know something is wrong. Mm-hmm. So there is a process by which you follow where you don't hear no. And that is making a written request for an assessment, right? Or a written request to have a 504 plan meeting. So let's first start with no on the IEP. Okay, so the process, and we're going to talk about this later, but the process for getting an IEP is through an assessment. That's the only way you'll ever get an IEP. You can't come to the school district with a doctor's note that my kid has autism, I need an IEP. The entry point is an assessment. So as a parent, you just need to put in writing, I'm making a request for an assessment for my kid. She's struggling with reading. And then the district, it's here in California, and it's different in each state. But for California, if you make a written request for an assessment, they have to provide a response, yes or no, within 15 calendar days. So, I have parents coming to me saying they've been asking for an assessment for like 2 years. So and school districts have a variety of ways of doing that, delaying, avoiding, circumventing. But the fastest path to getting your kid assessed is making a written assessment. I send an email, give a hard copy, get a date and time stamped, and you got 15 days, district, to either say, yes, we will assess your kid, or no. Mm-hmm. And that's how you avoid the first phase of a perpetual no, right? Because what usually happens for the IEP or the assessment process is, my kid is struggling with reading, will you assess? Well, let's do an SST meeting, the student study team meeting, student success team meeting. There's a variety of ways. And what they do is the school district will put a team together, you'll meet, they'll talk about the things they'll try. It's called response to intervention. But this SS team meeting can go on for years. Oh, well, can we have another SST meeting? Well, let's give it a little longer. Let's give it a little longer. Before you know it, your kid is in second grade. Mm-hmm. So the only path to a yes is by making a written request for assessment.
It's so simple at the end of the day, just a written
Yes.
request, but apparently it sounds like people don't know that.
They don't know that. They don't know that. Now, the truth is, it's in the law. Now, in
Mhm.
California, it's 15 days, but basically, a written request triggers a timeline. And that timeline for California is 15 days. And they can grant it and say, yes, we'll do an assessment. Or they could say, no, you're wrong. We disagree. Okay, and I know we're going to talk about this later as well, but basically, if they say no, you have procedural due process that you can pursue. So usually, if you come to them, make a written request, I would say 9.9 out of 10 times they'll do it.
Mm-hmm.
Now there are these it's not necessarily this population, but there may be a mom who wants her kid assessed. The kid is getting A's on their reading. They're reading at a second or third grade level, but they want their kid assessed. That one is going to get a no. And then it's going to be, that's a whole different scenario. But basically, if your kid is struggling with reading and there's something wrong, but you don't really know what it is, they'll do the assessment. That's the fastest way to a yes. It's the only way to a yes. You will not get an assessment without a written request.
Why would parents with a student who's doing really well want an assessment?
I've asked myself that. I think that first of all, I think that there's parents that just want some sort of validation that their kid is doing okay.
Oh, okay.
And then there's also kind of the overly ambitious early, this is my first kid. I want to make sure that my kid is doing great. And so basically it's kind of, I wouldn't say it's intentional, but it's just them being it's helicopter parenting to its worst case. And that would be the only reason, because in my mind, if you've got a kid that's actually reading at grade level, right on, let's
Doing
go.
Great.
Let's do it.
I would be totally happy with that.
Exactly. So I do think that it's not hard to get yes. You just have to know how to do it. And the fastest path is, the only path is written request, and you'll find out in 15 days whether or not you're going to hear yes or no.
Why no? What is the reason, especially if your kid is legitimately struggling and it's not a secret, why the no?
So the no would be because the teacher doesn't see it the way you see it. Right. Okay. And the school doesn't see it the way you see it. It's just, oh no, your kid is fine. Oh no, your kid is fine. A teacher that has 20 kindergarten kids or 25 first grade kids doesn't see it. It's such that, let's just take an ADHD kid, an ADD kid who's kind of just daydreaming all day and is flying under the radar. Mm-hmm. Not a problem kid, not anything like total F's on everything in first grade. No, like your kid is fine. You're not seeing it the way we're seeing it at school. And so there are reasons for no, but like I said, mommies and daddies are right 99% of the time. And I think it's all how you frame it and how you present your evidence, so to speak. Mm-hmm. My kid has gotten, I study with my kid every single Thursday for their Friday spelling test. And by the time we're done, after an hour's worth of practice, my kid only gets 50% of them right. And then when he goes to school the next day, he only has 25% of them right. And that's consistently. There's something wrong here. And when we talk about assessments, that's where we can tease all this out and figure out exactly what is wrong.
What is the difference between an informal disagreement with the school and an actual formal legal denial?
Uh-huh. So a formal legal denial would be through a document called prior written notice. And it's basically a notice saying we deny your request, and these are the reasons why we deny them.
Okay.
And at that point, you've been formally denied. However,
Mhm.
I think that you can pursue a formal denial in an informal approach or a formal approach.
Okay.
It is never a good idea to pursue things formally without sitting down and trying to resolve the issue. Yeah, you can easily resolve the issue with the facts and evidence. Now, the truth is, school districts may be unwilling to 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 have that conversation. At that point, you have to pursue it. But until you have exhausted all of your informal approaches to resolving this, formal the formal process, it's overwhelming, it takes a long time, it too long for a kid, and
Right.
ultimately there's a better way. It's not until it's untenable and there's no other way do you pursue it for. And different lawyers have different opinions on this, but my opinion is let's resolve this. I mean, this is we're talking about school and a kid.
Yeah.
We can do this pretty quickly without litigation.
Yeah. And that's a good piggyback to my next question. What can you walk us through the different legal options for challenging a school's decision, like complaints, due process? Is there mediation available?
Okay, so here in California, the way we do it is, well, there's the legal process, but informally, let's just say you hear no, and we'll just take no, I'm not going to assess your kid. And you've tried, and they're like, no, no, and you know there's something wrong. So at that point, you you can try to pull in the district personnel and have a conversation. You're going to always need to present your position with facts, right? My
Mhm.
kid has failed the last 9 out of 10 spelling tests, failed all of his reading comprehension tests, and he can't read, his first grade sight words. Like, this is why I need the assessment.
Right.
You pull in the district because the district has a special education department with a director of special education, with a program coordinator. There's a hierarchy of supports within the district. You pull in a meeting like that and you try to have an informed discussion with facts and evidence about why you want it. And if it's still no, the the trigger is to say, I'm filing for due process. Okay, so you can file for due process, and in so doing, that actually triggers several points in the system to handle it more informally until litigation. So you file for due process, and the first step is a resolution meeting. Now, both parties can agree to a resolution meeting, and that's informal. It's not with the judge. It's not with anyone other than the school district and the family. And their lawyers can be involved, or advocates, or whatever. But basically, from there, you meet again with the same people that you met with to try to informally.
Right.
But this is the first tier of informal resolution within the due process hierarchy. So oftentimes families will, or school districts, because either can say, no, I don't want a resolution session. So then the next step would be mediation. And both parties can agree to mediation or not. And that's still, in my mind, informal. It's not really technically formal until you go to litigation. But in terms of the formal due process, mediation is the next step. And if both parties agree to mediate, a family comes with their lawyer, district comes with their lawyer, and there's a judge or a mediator that you meet with, and then you try to resolve it. This is where most cases get resolved.
Okay. Yeah.
And you can resolve all the way up to the due process day when you meet, when you're going to basically have your case heard before a judge. And you can actually resolve it during the hearing, right? You can resolve until you've closed your case, basically. So, arrested. So, if you can resolve in mediation, I still consider that formal, but informal, but it's within the formal process of due process. And if you can't solve it there, then you go on to due process. If you're right, the district is going to settle. They have no interest in not settling a case they're going to lose. And districts know which cases they're going to lose. So, and again, this is the lawyer in me. I've been building my case, building my case, building my case, building my case. And finally, if I'm at mediation and they haven't backed down, mediation is where it all becomes very clear. If we go to hearing, you will lose.
Mm-hmm.
And so then they settle.
It seems so crazy that it gets to this point, right? Like it seems like it's something that should not get to this point. I mean, how long does this process typically take?
Oh, too long. Technically, so when you file for due process, the district has 10 days to respond. And then they have another 15 days. And again, don't hold me to these numbers, but I'm pretty sure I'm right. Then they have 15 days to schedule a mediation, a resolution hearing. And then from there, they schedule mediation. And then from there, they schedule due process. So yes, it is all way too long.
Yeah.
And it's a kid that we just need to teach to read.
We're just trying to get a kid to read. Yeah, that's the thing that I think is so crazy about this.
Exactly. So this is really where common sense, and again, lawyers have different approaches to this. And if you're being represented by a lawyer, again, do you want to resolve it or do you want to be right? Do you want to fight all the way for a judge to tell you you're right? And I usually tell people, if all you want to, if your goal is to be right and to sue, then I'm not the lawyer for you. I want to help your kid. And those aren't always the same thing.
Yeah.
So yeah, litigation is like the least best way to go.
What kind of documentation or evidence do you find really helps strengthen a parent's case if they're appealing a school's decision?
Okay, so using the request for an assessment criteria, it's the classroom performance. I would also say, let's just say it's an ADHD kid. A diagnosis of ADHD would help. My kid's on medication. My kid is struggling with attention. My kid's not getting good grades. I mean, everything that you're seeing is your facts, is your evidence, right? Everything that, all the failed tests, all of these crying nights, all of the hours it takes to do one page of math, that is the evidence when it comes to proving that your kid just needs to be assessed. When it comes to due process or mediation or just informally resolving it, if you've already had an assessment, you can use the assessment data. I find that the anecdotal evidence of classroom performance to really be what kind of turns the tables on the school district, because the standardized data is super important. All of that assessment data really helps understand what's going on with your kid. But honestly, how your kid is doing in the classroom is really how you can demonstrate in a very practical way that your kid is struggling. Mm-hmm. One of the things that I usually I can't tell you here in California how many fifth graders who are struggling with reading, I'll say to the teacher, I'll ask the teacher, does this kid know all of the letters of the alphabet? And they won't know. And by fifth grade, you'd assume. So
yeah, absolutely.
Yeah. So basically what I have seen, fifth grade, sixth grade, seventh grade, eighth grade, we close our meeting and we come back for a second meeting, and they have their to-dos, we have our to-dos. We find out that the kid only knows 17 letters. Well, then how is the kid going to read fifth grade content if he only knows 17 letters?
Yeah, impossible. No.
Exactly. So It's all of that very practical data that proves your point.
Mm-hmm. Yeah.
And it's very simple. Does a kid know all 17? Another thing in fifth grade, does this kid know how to syllabicate? It's a very, very basic skill. You learn it in second grade, third grade, whenever. Parents know these things intuitively. And when they read with their kids and they see that multi-syllabic words are a struggle, well, did they learn? Were they attentive that day or
Right.
that?
Yeah. Were they picking it up? Yeah. Mm-hmm.
So basically, it's those very basic skills, and that doesn't require a lawyer, right? That doesn't require a lawyer to ask these questions. Now, is it intimidating? Yes, because you have a bunch of people on the other side of the table, so to speak, that think they know your kid and that they know what's best for your kid, but you know what your daily experience is with your kid. My kids goes from line to line. Like he's reading here and then he reads up here and then he reads down here. Well, what is that?
Yeah. Something's off there. Yeah.
Exactly.
Mm-hmm.
So
Yeah.
it's very basic evidence that can support your case against no.
Mm-hmm.
And the results would be grades, actual classroom performance. And those two things are invariably the anecdotal evidence and grades. Those two things right there, along with all of the parents' experience, is enough to sway a school district in a very unemotional, objective discussion with the school district.
All right. Well, that was awesome information, Michelle. We really appreciate you giving us the rundown on that. And we really appreciate all you joining us today on A Peaceful Path. You know, if you're facing a denial, don't know what to do, Michelle is here to help. You can visit michellebeckerlaw.com to learn more or schedule a consultation. And if you found this episode helpful, please subscribe, share it with anybody you think could, get use out of this and has maybe heard no and can get some closure on that. Michelle, great to have you here. Thanks so much for your time.
Thanks for having me. See you soon.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.